Okay. Good morning, Your Honor. This is Waverly Fu for the seller and the defendant cross-complaint W&B Investment Group and its owner, Vincent Hui. I have reviewed and studied your tentative rulings. And before I even start my oral argument, I would like to direct the court's attention to the page 3 of the 4 of tentative ruling and identify some prima facie mistake on the facts. If you look at the page number 3 from the bottom of the page, paragraph number 1, 2, 3, 4 from the page 3. In the tentative ruling, court says W&B and Hui argued based on the new facts, including 3 of them. First American Title issued a defective title report. First buyer reviewed the report, and the purchase agreement imposed affirmative duties, and the title defect was disclosed to the buyer. Those facts are correct. However, the court continued to state that in oppositions, that Milano argued that the purported new facts were available at the time of reaching the motion. I'm assuming this is a regional cross-complaint, and based on the same purchase agreement, and title report already included on the first amended cross-complaint. So here, I would like to ask court to review the cross-complaints I have filed with the court on July 31st, 2024. And I'm going to ask the opposing counsel to identify where exactly in my pleading paper I have stated those facts that I stated in the motion for reconsideration, and where exactly the title report was included in my first amended cross-complaint as an attachment or as exhibit. It was not. I drafted this document myself, and I filed it July 31st. So by that time, all those facts was not available to us. And because the discovery has not even started yet. Now we know all these facts through the due diligence, and that's why I included in the motion for reconsiderations. So statements on this tentative ruling was simply wrong because it was not alleged, this new facts was not alleged in the original cross-complaint by W&B. And the second, I would like to remind this court why we are here. We are here because 3 and 4 years ago, in the November 2021 transaction, all the parties involved here, first buyer Tu Van Lu, second buyer Cam Lu and Milano, and First American Title Company, and the escrow company, they all did not read the documents. From the first day of when the title insurance report was issued to the last day when the grand deed was recorded, everybody closed their eyes. Everybody did not read the document and finish the transactions and causing all these problems and drag this litigation into today. The same thing here today, Your Honor. The Milano did not read the document clearly. If you read the documents, I would like to ask pledge this court to read my original documents.
Hold on. So this goes beyond the motion for reconsideration. You're going to the underlying facts right now. You're arguing things that, in my view, are not salient for the motion before the court.
Your Honor, that's not correct. Because for the motion, that's my second point. For the motion for reconsiderations, I think if you read the 3 paragraphs of your court's legal analysis, the court missed the point here. For the motion to reconsideration to prevail, the moving party is not asking the court to identify what exactly is written, the facts on the original complaint, what exactly new facts was pledged in the motion for reconsideration. That's, Your Honor, a high school graduate or a college graduate without any legal expertise or training can do that with sufficiency. We are here asking court to decide one specific and narrowly focused issue, and that issue is if there is reasonable possibilities for the W&B and the Hui to amend, to cure the defects through the amendment. That's the only issue.
Hold on.
Yes.
So your 5 minutes are up. I'm going to make a couple of comments, and then I'm going to turn the floor over to the other side. First of all, I find aspects of your argument to be disrespectful and inappropriate. Secondly, the reason I limited you to 5 minutes is because at the last hearing, your oral argument went on, and that was on the demur, went on for, I believe, in excess of 15 minutes. And during that argument, you propounded multiple questions to the court as if you were cross-examining the court, and I found that disrespectful and inappropriate as well, which is why I limited you to 5 minutes today. And so you've now reached your 5-minute time limit. I have cut you off. I'm now going to invite opposing parties to respond. Mr. Stepanian, did you wish to respond?
Yes, Your Honor. Thank you. So, Your Honor, as the court correctly stated, the moving side is pretty much trying to argue the murder, but the court has already ruled on the murder. Their so-called new facts, which are pretty much based on the purchase and sale agreement and the title report, which were available to them by virtue of them having been party to the transaction. So those are not new facts, and they cannot be new facts under by any stretch. They're pretty much going over the transaction, and the circumstances surrounding have been outlined in the cross-complaint to begin with. So there are no new facts, there are no new circumstances, and that's why the motion should be denied, and the court, I think, should adopt its tentative. Thank you.
Thank you. Ms. Sun, did you wish to weigh in?
Yes, Your Honor. I just want to pinpoint the facts that has already been stated in our original pleading, and I'd like to draw Ms. Full's attention to paragraph 19 of the purchase agreement, where it says that seller has 7 days after acceptance to deliver to buyer all reports, and that would include the preliminary title report. And then the paragraph follows that seller is responsible under paragraph 18 to provide those reports. And paragraph 18A says that buyer shall be provided a current preliminary title report. So this refers to the title report that Ms. Full is asking the court to reconsider right now, arguing that that's new fact. That's not new fact. It's already in the original pleading, in the original purchase contract. So she has not met her burden of providing any new facts at all. And the court is correct. She's just rehashing old wine into new bottles. And that's all we want to point out to Ms. Full, that this is something that she needs to pay attention to rather than wasting everybody's time. Thank you, Your Honor.
Thank you. Mr. Olson, did you wish to weigh in?
No, Your Honor, I don't have any comments.
All right, thank you. Ms. Goldberg?
Your Honor, the only comment that I would make is that the alleged new facts of the preliminary title report and the purchase and sale agreement were both brought up by Ms. Fu in the oral argument at the demur hearing, and with that, we would submit on the tentative.
All right, thank you very much. I will adopt my tentative as my final ruling in this matter. I will ask then just a moment, please.
Your Honor, as moving party, can we get the last say?
Sure, go ahead.
Okay. For the record, this court only allowed the moving party WNB to argue for 5 minutes. The moving party WNB did not get fair opportunities to present its oral argument in its hearing. And this hearing is incomplete because we have several remaining issues we'd like to argue, present to this court. And if I may, for the second time, to remind this court, because I happen to have because last time this court has the court reporter, so had the privilege and opportunities to review the copy of the transcript from the last hearing on November 25th, 2024. Your Honor, during the last hearing, I respectfully request this court to provide the legal authorities and by statutes or case laws on the very naturally specific issues on why this court decided there is absolutely no reasonable possibilities for the WNB and Hui to amend, accrue the defects by amendment, even though the bounty of case laws and the statutes cited by our motions.
Hold on, you're re-arguing the demur again.
I'm not arguing the demur, Your Honor.
Hold on, that's exactly what counsel just said. You're re-arguing the demur again.
Because earlier,
don't interrupt me. All right, you've interrupted me again. All right, and I would also point out the reason I've limited your argument today because during our last argument, you started talking about things that were not in your papers. You started talking about equitable estoppel and all sorts of things that were not in your papers anywhere. You went off on tangents that I thought were inappropriate. You're doing it again. And so based upon that, I'm going to give you 1 minute to wrap it up, and that'll be the end of it, okay? And also because your argument style I find to be disrespectful. You essentially tried to cross-examine the court at the last appearance, and you apparently are doing it again today. And so, and the fact is, and the record should also reflect, because we're recording it, that you came in here today, the court had posted a tentative, all other counsel, we have 4 other attorneys on the line who are ready to go, and you came in and asked for a continuance based upon the fact that there was no court reporter here, and I had to explain to you at the beginning of this hearing that IC courts in Los Angeles County have not provided court reporters for a number of years now, and that's a well-known fact, and that it would be incumbent upon the parties to provide their own court reporter. And so you came in and asked for a continuance today because there was no court reporter here, which is something you should have been aware of, and basically I'm sure all other counsel are fully aware of that fact. And so I'm going to give you 1 more minute to wrap it up, and then we're going to be done.
Your Honor, there's 3 oppositions were filed. Then there's oppositions by First American Title that we have not addressed during this oral argument hearing, and in your tentative ruling, it was not addressed and not analyzed at all. Because in our motion for reconsideration, we brought a new cause of action, it's promissory estoppel. We believe in our motion for reconsideration, we fully analyzed that, we met the burden, and we would like the court to consider to amend the leave, to grant the leave to amend. All we ask this court to do is just one thing, is to please give us one opportunity, just one opportunity to amend our complaint in order for us, the party, to be able to have the fair opportunity to prosecute their claims on its merits. That's all we ask. The court has not provided one opportunity, yet the court already improperly positioned itself as a fact defender, determining, well, WNB, you got no claims against all the parties who are involved in this transaction 4 years ago. And a lot of mistakes made by multiple parties through the different stage of this transaction. And I want to remind this court, seller paid for all these services, even though seller did not prepare all these documents, but paid for these services.
Your minute is up. All right, I'm going to adopt my tentative and my final ruling. We have a future date, a couple of future dates coming up. Looks like we're coming up on a motion to expunge lis pendens on 122 and hearing on motion for attorney's fees on 128. We can deal with those at the appropriate time.
Your Honor,
Yeah.
I have a last question because in our motion, we alleged a new party, which is WB's leasing agent, Kenneth. In your tentative ruling that court decided to adopt, it was not addressed at all. The court provided 0 analysis on what is the court's position on that ruling, and by denying the motion in its entirety. I would like to get the clarification from the court regarding our allegations on the new parties, Kenneth, as a leasing agent. On whether court would allow us to amend our complaint by adding a new party.
I've already ruled. The tentative has been posted. I've adopted as my final. The ruling speaks for itself. The ruling on the demur speaks for itself. And there's nothing more to talk about in this. So that's my ruling. That'll take care of it. We'll see everybody back on that next court date. And then per the actual ruling, I've asked for W and B and Lou or Lou to give notice of this, okay? And that'll take care of it. Anything further from any other parties?
Nothing further, Your Honor.
No, Your Honor.
Thank you very much. Good luck.
Thank you, Your Honor.
Thank you. Good luck.
Now I'm ending my recording for the record.